Good evening, everyone. I'm Dr. Miriam Ruman, a teaching professor in the Department of History at URI, and welcome to Long Road to the Vote, URI's Suffrage Centennial Lecture Series. This year-long series has commemorated the 100th anniversary of the 19th Amendment and the 150th anniversary of the 15th Amendment. And tonight's panel on felon disenfranchisement and the history of women's voting rights is our final presentation in this year-long series. Tonight's presentation will start with a short video about the overall series.
History is a central humanities discipline, and the centennial of the 19th Amendment is a critical milestone in American women's and political history.
The history of suffrage in the United States is complex, but we, the people, do have the tools within our power to make the changes that can move us forward.
For history students to be able to see what an important role Rhode Island played in fighting for women's suffrage, I think is going to really influence the way students think about social movements.
Especially with this past election, we've seen what a relevant issue voting rights is. It's definitely refreshing, but also important to listen to actual experts who have been in this field share their expertise.
Reminds us that these issues are not over and that they still need strides to kind of overcome some of the barriers.
As we started our planning, we realized that 2020 was not only the 100th anniversary of the 19th Amendment, granting American women the right to vote, but also the 150th anniversary of the 15th Amendment, which at least nominally enfranchised Black men, although it took another century for that right to really be realized.
My students had the opportunity to analyze a primary source document from 1916. The document is from Rhode Island, a resolution in favor of women's suffrage, or the Susan B. Anthony Amendment as it was called back then.
And we just kind of wanted to find out, who they were, where they were born, where they were from, what they liked to do, and these women, their stories weren't told and now they are.
It's important to learn about the suffragists and their motivations and exactly what they were aiming to do.
We hope people will walk away with an appreciation for the importance of the humanities, for interpreting current events and understanding the world we live in.
Thank you. Tonight, we welcome Professor Pippa Holloway to discuss felon disenfranchisement and the history of women's voting rights. We will have questions and answers after the panel, so please type any questions you have into the chat at any time, and be sure to like and share this talk on social media. Now, I'd like to welcome Jennifer Rourke, who will introduce our speaker. Jennifer is an activist from Warwick, Rhode Island, and a candidate for Rhode Island State Senate District number 29. Jennifer is a member of the Rhode Island Political Cooperative, a progressive group whose issues include criminal justice reform. Welcome, and thank you, Jennifer.
Good evening. Thank you for having me. So I am going to tell you a little bit about Dr. Pippa Holloway. Dr. Holloway is the Douglas Southall Freeman Distinguished Professor of History at the University of Richmond. Her research and teaching focuses on legal and political culture in the 19th and 20th century United States. She teaches classes on the history of elections and voting, Southern law and politics, prisons, mass incarceration, and LGBTQ history. Her most recent monograph is titled Living in Infamy, Felon Disenfranchisement and the History of American Citizenship. She is also the author of Sexuality, Politics, and Social Control in Virginia, 1920 to 1945, and editor of Other Souths, Diversity and Difference in the U.S., South, Reconstruction to Present. Her most recent article, Testimonial Incapacity in Criminal Defendants in the South, is part of her current research on the history of 19th century limitations on court testimony. She presently serves on the Committee on College and University Governance for the American Association of University. Please welcome Dr. Holloway.
Great. Thank you for the warm welcome. It's wonderful to be part of this series. It's really an honor to be part of such a ambitious and interesting series at the University of Rhode Island. And I want to thank the faculty and staff that made my visit possible, as well as the amazing technical support I've experienced already. And also it was a real honor and privilege to meet Jennifer Rourke, and thank you very much for the kind introduction. I'm going to do my talk today as a PowerPoint. And I'm going to go pretty quickly in order to cover a lot of ground. So hold on to your hats and get ready for the PowerPoint. So my talk today is felony disfranchisement in the history of women's voting rights. And I wanted to actually start with a comment in reference to the title of my talk. You may have noticed Professor Ruman refer to my talk as being about felon disenfranchisement, and yet here my PowerPoint says felon disfranchisement. So you may be noticing that there's a missing E in the title as I have it written. This is because this is a word that in fact is used both ways. Many people in the present use the term disenfranchisement, but the term in the 19th century, the term of most of the sources and historic documents I work with, is felon disfranchisement. So that's the term that I'll be using throughout my presentation today. And here's a quick overview of my talk today. Really, I'm sort of packaging 2 talks into one, or possibly even 3 talks into one. I'm going to be talking about felon disfranchisement past and present, and I'll try to dig a little bit into the situation and history in Rhode Island and New England as part of that. I want to talk about women's suffrage and felon disfranchisement, how the women's suffrage movement interacted with this issue. And finally, I want to talk about specific women who were affected by felon disfranchisement. So first, your overview of felon disfranchisement in the U.S., with a little bit of a focus on the New England region today. Felon disfranchisement has been historically one of the main reasons that Americans lose the right to vote. When I began this project in the early 2000s, it was the primary reason why anyone who would have otherwise been able to vote with age and citizenship lost their voting rights. And for better or for worse, probably for worse, that's actually, in some ways, that's actually decreasing today. Today, so here's my point. It's good that, as you can see from this graph, at least in my opinion, it's good, that we do have fewer people in the United States that are incarcerated. So there's been a slight drop in incarceration, and that has led to a slight drop in the number of people who've lost their right to vote due to a prior conviction. But the bigger issue is that felon disfranchisement today is not as big a topic, or not as important, or not as a significant or impactful issue as it was maybe 10 years ago, because all of the other techniques for denying people the right to vote have expanded. So if you've been paying much attention to current electoral politics, you know that there have been issues in many states, especially in the past few months, that have made voting harder. There's a concerted effort today in the United States, in many states, to make voting harder. And so while felon disfranchisement is still an issue, it's a reminder that there's a growing number of obstacles to vote that a growing number of Americans are facing. So who loses the right to vote due to a criminal conviction in the United States? In 2 states, Maine and Vermont, nobody loses the right to vote. And in fact, those 2 states, you can vote while you're incarcerated. California also has some provisions that allow some incarcerated individuals to vote. In 17 states, the largest group, which includes Rhode Island and Massachusetts, you are disfranchised while you're in prison, but as soon as you're released, you're able to vote. In 4 states, including your neighbor Connecticut, you're disfranchised during probation and parole. And in 16 states, you lose the right to vote during prison, parole, and probation. And then in 11 states, the big one here is that in 11 states in the United States, some or all individuals convicted of a felony lose the right to vote for their entire lives. With that, and in those cases, there are some mechanisms by which they can petition to get them restored. And we'll be talking about the kind of limits of that. So there's 11 states in the US in which you're disfranchised for life following conviction of a felony. And you can see from this map here that there's quite a bit of variations among states and regions. You can see the New England states are the part of the country where there are the smallest number of people who are facing disfranchisement due to current or previous incarceration. You can see the southeastern states are the parts of the country where the numbers are the highest. Western states are a mixed bag, but the real bulk of the impact of these laws today remains in the southern states. You can see from this chart that while a number of different populations are impacted by these laws, the gray part of this pie graph is people who are currently incarcerated, and those are about 25% of those that can't vote or can't vote due to a current incarceration. About a third of the population here are people that are on probation and parole, but a full 43% of the people that are disfranchised post-sentence, after completing their sentence, 43% of the population of people who've lost their right to vote are post-sentence. And that, in other words, that 43% are the ones clustered most significantly in southeastern states, as well as disproportionately African American. And you can see from this graph the incredible racial disparities of these laws. In some states, if you're looking carefully at the barometer in the lower right-hand corner, you can see that over 20% of the Black population in some states has lost the right to vote due to a felony conviction. 1 in 5 African Americans in places like Tennessee, just under 1 in 5 African Americans in places like Kentucky, Alabama, Mississippi, and Florida. Colorado is also up there too. A significant part of the American Black population are affected by these laws. Data is much more difficult to obtain on Latinx people and mass incarceration and disfranchisement, but from what data we have, this is a population that's also disproportionately affected by these laws, and a population in the southeastern US, as well as to some extent the Southwest, that is also disproportionately affected. And finally, women. Women represent a much smaller percentage of the incarcerated population in the United States, and therefore they represent a much smaller percentage of the population who has lost the right to vote due to a current or former incarceration. But you can see from this graph that the number of women facing incarceration has increased quite dramatically over the past 40 years. So in a sense, women are the largest growing number of people affected by these laws. So I want to talk for a few minutes about felon disfranchisement in New England. How are these laws in past and present somewhat unique in New England states? And I want to take a look for a minute at the actual constitutional provisions in the state of Rhode Island. Rhode Island's provision disfranchising for crime dates back to 1843, one of the early constitutions of the state. And it was a pretty standard provision. Many American states passed almost identical provisions in the 1830s and 40s. It says if you're convicted of bribery or of any crime deemed infamous at common law, you can't vote unless you're expressly restored by an act of the General Assembly. We'll talk a little bit more about that General Assembly Act in a minute. That's a little bit of an outlier. That is only a small number of states had that kind of provision for restoration of voting rights. It was more common for a governor or a court to restore this right, but there were other states like Rhode Island that had this kind of provision. This was amended in 1973. The main thing here is that they substitute felony for the term infamous, and that it's clear that it applies to people that are serving a prison sentence and subsequent to such imprisonment. So after 1973, this continues to follow people out of prison, again, unless restored by the General Assembly. In 1986, the state of Rhode Island had a ballot question. The citizens of the state were asked to vote on making restoration of voting rights automatic after the full sentence, including probation and parole, had been served. And in 1986, they turned that down. In 2006, though, the constitutional amendment came up again, and the citizens of Rhode Island voted to restore the right to vote to people while they were on probation and parole. This provision also triggered the passage of a law, the 2006 Restoration of Voting Rights Act, which allows the Department of Corrections to act as a voter registration agency and offers all inmates the opportunity to register to vote during their discharge. And I want to note that this is a pretty big deal. It's a big deal for a number of reasons. First of all, Rhode Island was the first state to restore voting rights to ex-offenders by a popular vote. This has happened in a couple of instances since then, most recently Florida, but you guys were the first to do this. And it also is something of a model that some, although not all states have today, which is not just a restoration of voting rights, but an active granting of voting rights. In other words, when you were discharged from incarceration, you're given a voting rights form and offered to fill that and have the opportunity to fill that out. That's really quite different than many states in which there's obscure paperwork that you have to request, and this kind of restoration is far from seamless. Connecticut's actually an interesting example to compare Rhode Island to. In Connecticut today, you lose the right to vote while on parole, though not while you're on probation. So you can't vote while you're on parole, but you can vote while you're on probation. Also in Connecticut, they have legal financial obligations. So if you're convicted out of state or in federal courts, you must pay all fines incurred in conjunction with the conviction in order to vote again. So note that does not apply to people convicted in in-state courts. And there's also no automatic registration. So when you are eligible to vote in Connecticut, you have to fill out a form and register, unlike the more automatic or transparent process in Rhode Island. And if you're staring at that slide and trying to figure out exactly what I mean by all of these things, understand that that's more of a feature than a bug, I would say. The fact is that this is hard to understand. If you're wondering what the difference between parole and probation is and trying to figure out what exactly constitutes a legal financial obligation, now imagine that you're someone who's just been released from incarceration and are trying to figure out whether you're convicted in state or federal or out of state courts. All of this means that getting the right to vote in Connecticut after a criminal conviction is much harder. And on this next slide, we can see the impacts of that. You can see, I tried to circle these as best I could, although you will note that I circled the wrong number. Sorry about that. In the state of Connecticut, if you follow the line of across, you can see that I have accidentally circled California there. In the state of Connecticut, 1.64% of the population still can't vote because of a current or prior felony conviction. Whereas in the state of Rhode Island, where your laws are only apply to people that are in prison and do not have these strange loopholes that involve post-conviction, legal financial obligations, distinctions between probation and parole, you can see that in Rhode Island, it's only 0.33% of the population. So this is the sort of graph, if you look even, or the sort of table that enables you to really see the impact, how these laws make the experience of voting and the impacts of criminal conviction really varied from state to state. If you look even more carefully on here, you can see the top line, Alabama, 8.94% of the total population of Alabama is disfranchised for a crime. Florida, you can see there's 7.69, and Tennessee, 9% of the population. So in other states, we have really significant parts of the population, significant numbers, as well as significant racial disparities with regard to these laws. All right, let's talk about the past. You invited a historian to speak, so I definitely want to talk to you quite a bit about what happened in the past. These laws had their original roots in ancient and early modern Europe. They began in ancient Greece and Rome. The idea of elections and citizenship were born in that era, to put it sort of very roughly. And the idea of elections and citizenship also came with the idea that in some circumstances you might lose that right of citizenship and that right to participate in elections. There was also traditions in English common law and continental European law by which people lost the right to vote after certain crimes. But the main takeaway for here is this is quite rare. In all of these instances, it had to be a major crime, a felony crime, or even a significant felony like something like treason. And in fact, many of the crimes for which people lost the right to vote in these contexts were also punishable by execution. So quite honestly, losing the right to vote was one of the lesser punishments of a crime by which you might lose your life. So this was a penalty that was extremely rare in this context. In the United States before the Civil War, my research shows that these laws were much more common in southern than northern states. And I did a pretty careful analysis, a state-by-state reading of constitutions and statutes during this period, and found that southern states had the most stringent laws denying people the right to vote following a criminal conviction. They had the ones with the largest reach, impacting the largest number of crimes. In contrast, northeastern states were states that were more likely to have looser laws, exceptions to laws, or laws that didn't deny people the right to vote following a criminal conviction at all. After 1865, southern states began to expand their laws disfranchising for crimes. And this is one of the major contributions of my scholarship to the historical literature, as well as to some extent the legal literature, and even in some cases current litigation. So I proved that this was a deliberate effort after the Civil War aimed at the newly enfranchised African Americans to prevent them from voting. Now, you probably know that there were a lot of techniques used in the South in this period to prevent newly freed African Americans from voting, things like literacy tests, poll taxes, and more. However, my research shows that actually before any of those things, the first technique after the war was felon disfranchisement. And this is a long slide, and I know you're not supposed to have really texty PowerPoint slides, but this is a really powerful story that I want to say carefully and accurately. So in North Carolina in 1866, right after the Civil War, a group of white Democrats had an idea. They undertook a campaign of mass whippings of African-American men in order to disfranchise them. An outraged U.S. Army officer witnessing this wrote to his superiors in Washington to explain the situation. White former rebels, he wrote, conspired to, quote, seize Negroes, procure convictions for petty offenses punishable at the whipping post, and thus disqualify them forever from voting. In one county, he had heard reports that whites had already whipped over 60 men, and by next spring, they would disqualify about all of them. This was due to the fact that in North Carolina, individuals whipped as punishment for petty crime lost the right to vote. Many whites celebrated how the whipping campaign enabled them to, quote, head off Congress from making the Negroes voters. One legislator stated, we are licking them now, and if we keep on, we can lick them all by next year, and none of them can vote. Now, I want to take a deep breath and acknowledge what a powerful and truly terrifying and awful set of quotes that is. This tells us that violence, overt uses of violence, was aimed at newly freed slaves in order to stop them from voting. You can think about this slide in this instance in all kinds of ways that connect to the present. It makes you think about, or it makes me think about, the political work that violence does. The long history of racial violence against African Americans, and the ways that in very targeted ways this is used to deny them some of the most fundamental rights of citizenship. Now, part of why North Carolina, or why whites in North Carolina had this idea to do this was because the 14th Amendment was about to be passed at this point. The 14th Amendment in 1866, at this time in 1866, had passed Congress and was going out to the states for ratification. And there's a line in the 14th Amendment, it's a section 2, and it's a fairly complicated amendment, but the basic line here is except for rebellion or other crime. In short, what this does is it says basically that states have to let everybody vote if they're a citizen, they're a male citizen, unless they're men who have participated in rebellion or other crime. And southern states used this exception, or interpreted this as an exception, to implement that whipping campaign, and then not long afterwards to implement a similar campaign disfranchising individuals for petty theft. So in the 1870s, southern states decided that they would again take advantage of this element of the 14th Amendment to target people to lose the right to vote for being convicted of petty, by which we mean minor or low-level threat. And this was acknowledged by both supporters and opponents that this targeted African-American voters on election day. All of this adds up to a real understanding of the connection in the South between prisoners and legal culture. And my basic argument that I can really only go into briefly here, but go into much more in my book, is that there's a reason that southern states in this period expanded these laws. And it's actually a sort of analogous reason why New England states in the previous decades had more of a critical relationship with these laws. And that's because both enslaved people and incarcerated people had technically the same legal status. Both were cast out, marked, and degraded in the eyes of the law and the state. And the history of racial slavery in the South gave disfranchisement for crime a stronger hold on legal culture in the South, both before and after 1865. So I want to talk for a little bit now. That's your basic introduction to felon disfranchisement and the history thereof, with a regional focus. And I want to tilt now to sort of the second half of my lecture, which talks about the historical connections between disfranchising women and felons. So on the eve of the ratification of the 14th Amendment, there were basically three populations cast out of suffrage, or probably should have also put the 13th Amendment, basically in 1865. In 1865, three groups couldn't vote: women, African Americans, and convicted criminals. And these were all populations that in the eyes of those that held electoral and political power in the United States, in the eyes of white politicians, these were all populations that were believed to be dependent and degraded. If you look back at the 14th Amendment, Section 2, you see that not only, and I had the middle line underlined in the first time I showed you this slide, But you can see here also that the 14th Amendment focuses on men's voting, that women are also written out of the 14th Amendment. So in a sense, you could think about this amendment as an amendment that gives African Americans citizenship rights, but underscores that men, in fact, underscores 3 times that men, not women, shall have the benefit of counting as citizens for voting, and that people with people that are convicted of crimes are also have a limited access to these rights. So in a sense, the 14th Amendment connects women and ex-offenders or felons with disfranchisement or writing out of the rights of citizenship. In the course of the women's suffrage movement, many people who advocated for women's suffrage, as well as people that oppose women's suffrage, made reference to this connection. And these are some quotes from an anti-suffragist, John Vertees, who was from Tennessee and did not believe that women should have the right to vote. And he used this connection between women and incarcerated people to argue that women should not get the right to vote. The women, children, aliens, infamous persons, and corporations of Tennessee are all citizens, and as such, they have their citizenship, but they do not vote. Even the suffragettes do not protest against the disfranchisement of minors, felons, and aliens. This is, in fact, an admission that considerations apart from personal or individual rights may be and indeed are controlling. In other words, he's saying, it is fine. It's fine to take voting rights away from some people. That's completely standard, and even the suffragists have to admit that some people just don't get to vote. In contrast, activists in the women's suffrage movement spoke back and said that you shouldn't compare women to these populations. Here's Elizabeth Cady Stanton. Respectful, law-abiding women are thrust outside the pale of political considerations, with traitors, idiots, minors, with those guilty of bribery, larceny, and infamous crime. What a category is this to place your mothers, wives, and daughters? And Daniel Livermore says, as the law now stands, idiots, felons, lunatics, and women are excluded from the polls. Giving the ballot to worthy, intelligent women will lift the wives, mothers, and daughters and sisters of our intelligent citizens out of the category of idiots, lunatics, and felons. One more, George Curtis in New York, the lunatic may emerge from the cloud and resume his rights. The idiot may be molded into the full citizen. Even the criminal may be pardoned and restored, but nothing can remove women from this enormous and extraordinary disability. This is a picture that was displayed at the 1993 World's Columbian Exhibition in the women's portion of that exhibition. It was displayed by the suffragist activists that were there. And you can see there's a picture of Frances Willard in the middle, looking as a dignified women's suffrage activist would in that time. And you can see she's surrounded here. You can see at the bottom it says American Women and Her Political Peers. And she's surrounded by caricatures of other populations that have lost the right to vote. And the argument here is that this woman, Frances Willard, who you'll notice is white and upper class, they're saying that a white upper class woman like her should not be connected to populations that they see as inferior to her. But yet all these populations can't vote. And I guess the bottom line for me here is that this stuff is really complicated. The women's suffrage movement took a political position that I think a lot of us would find really troubling today, of arguing that women were better than some of these populations, that this was a reason why women should have the right to vote. It exposes the racist, the classist, the ableist rhetoric of the women's suffrage movement, but it also reveals the complicated political situation that they were struggling with. Now, one of the reasons I started writing about women and felon disfranchisement was this case I ran across. It's a case from the Illinois Supreme Court in 1910. And in this case, this woman she was convicted of a major larceny. And in the context of sentencing her, the judge said something really interesting. He said, the plaintiff in error is a woman, and the rights she's lost are more restricted than those of a man. But they are all she had, and she could lose no more. So basically, this judge is saying, I can't take away your right to vote because you can't vote anyway. But I guess you can lose some things, and these are all the rights you have, so we're going to take them away. This makes us think about, or is an important way to start thinking about the other collateral consequences of a criminal conviction. So in addition to being incarcerated, what other rights she couldn't lose? She couldn't vote. She lost her freedom by being incarcerated. And what other rights would a woman have lost after incarceration in the late 19th and early 20th century. And historians and activists and people today in general refers to these as collateral consequences of a criminal conviction. So in other words, today you might lose the right to vote. You might lose other rights as well. Here's some of the rights you would have lost in the 19th century. You'd have lost the right to act as a witness in judicial proceedings. And that's actually a topic I've been writing about as another collateral consequence of criminal conviction. You would have lost the right to serve as an insurance broker, a medical license, etc., liquor license, executor of wills, hold public office, sorry about the typo there, and parental rights. And you can see here, these are rights that in many cases would have been for men, in many cases would have been for upper class men. But in reading petitions by women for the restoration of their rights, one of the ones that I read quite often was to obtain a liquor license. And working in a bar would have been an opportunity for immigrant or working class women to have a job, and not being able to obtain a liquor license was actually a pretty big deal for women in the late 19th and early 20th century. So that's a collateral consequence that would have really affected them. I pulled a little information about collateral consequences in Rhode Island today. This is a fairly terrible slide, and I apologize. I was trying to summarize or excerpt some of the things that were in a fairly long table. You can see at the top here that in Rhode Island today, there are 213 or 221. Basically, there was a graph here with about 220 lines on it. And each of those lines is a different collateral consequence of a felony conviction facing people in Rhode Island today. And you can see, for example, that convicted felons in Rhode Island are ineligible to visit inmates in prison. They can't work as private detectives. They can't work as social workers. They're ineligible for victim compensation from the Criminal Royalties Fund. They can't serve as jurors, and they can't work as plumbers. And there are 200 and something more things like that that affect people with criminal convictions in the state of Rhode Island today. And when I think back about the history that I've studied with regard to the collateral consequences that women faced, it made me think that this is a list of collateral consequences that really you can analyze through the lens of intersectionality, right? And so that these are going to be collateral consequences that are a big deal for some based on their race or class or ethnicity or immigration status. These are going to be collateral consequences that affect some people tremendously. Say the ability to visit an inmate. You might not be able to see your parent, your child, or your spouse. But for other people, that might not be such a big deal because they may not have incarcerated family members. And so collateral consequences today, as in the past, are shaped by people's race, class, gender, and other factors. And you can see here, this is a national list of all the wide range of restrictions following a criminal conviction, and all the different ways that a criminal conviction can affect your life. All right, the last part of this, I want to talk about efforts by convicted women to regain their voting rights. Now, when I first wrote my book, I realized my book pretty much ends in about 1920. And I realized by writing about felon disfranchisement prior to 1920, I was writing primarily about men losing the right to vote and not so much women. So after my book was done, I did a little more research, and wrote an article specifically focusing on women with prior convictions and their efforts to regain their voting rights. And this will give me an opportunity to talk a little bit about the process of restoration of voting rights. So in many states back then, and in some states still today, after a criminal conviction, you have to do quite a bit of paperwork and you have to appeal for restoration. So in other words, if you lose the right to vote in 1920 in Missouri, and you want to vote again now that you're out of prison, you have to fill out forms, you have to get petitions, and you have to submit these to the government. You have to submit these to the courts, in fact, to be approved. And so what I did in my research was I went through archives and I looked up these are papers that were largely saved by parole commissions. So I was able to look up these petitions and find efforts by women in the 1920s and 30s to get their voting rights back. And these forms that I found had some really interesting things on them. And in fact, you're probably already noticing one here. You can see that Anna Hunting, when she filled out her form in 1921, now remember, this is January 1921. Women have only been able to vote for a few months at this point. Anna Hunting was ready, though. She knew that she wanted to vote, but she had a prior conviction. So she picks this form up, and she realized that it says his on it, that his conduct had been that of a good citizen. Well, she didn't stop. She crossed that his out, and she put her on there. and then proceeded to get this form signed. She carried it around her neighborhood. If you look carefully, you can see she lives in a rural area. All those rural route addresses on there. And she went and found a lot of men in her neighborhood. A lot of these are men with probably immigrant names, probably immigrant men. You can see on the right side, there's butchers, there's blacksmiths, there's farmers, there's merchants. She managed to get at the bottom, she got the Catholic priest to sign it and the mail carrier for Route 15 to sign it. So she got all of these men to attest that she should get the right to vote. And then she mailed it into the state of Missouri. And indeed, she got her voting rights back. So a few months after women got the right to vote in the United States, Anna Hunting got her voting rights restored by the governor of Missouri. Another story I found was that of a woman named Annie Tassin. I did a lot of research in Missouri court records for all this. Annie Tassin, who's applying for citizenship following her criminal conviction in 1932. I'll read this to you because I know sometimes students have trouble with cursive in particular. Dear Mr. Brown, I am writing you in regards to the blanks that has to be filled out to get your citizen papers. As I would love to have my citizenship back, for it means so much to me in my life to live. As I was unfortunate and falsely accused, it has put a black shadow over my life. And God knows I want to live a true life, as I am identified by so many organizations. I would like to have my citizenship back. Will you please kindly send me the papers to fill out at once? I am Annie Tassin. I was discharged from the state prison on the 16th or 17th day of March. My register number, thanking you again kindly, Annie Tassin. So here's Ms. Tassin writing this note. This is just to ask for the forms, but she is desperate to get her right to vote back. She managed to get the form and she filled this out. And I can tell you from my archival research that I discovered that Ms. Tassin was was African American. So here we have a black woman in Missouri in the 1930s who is trying to get her voting rights back. You can see on this form that she was working as a laundress. She also crossed out his and put her on the top there. Says here she was convicted of burglary in the 2nd degree. They asked her date of conviction and she said she couldn't remember exactly. Before what court, circuit court, criminal, you can see she's trying really hard to fill this out accurately. And that's a reminder of today still, this is a complicated process. And in states that have these kinds of requirements for petitions and restorations and efforts to regain your citizenship, knowing all these dates, having all this information, managing to get the form filled out right are obstacles that people still today face. You can see there a few other things. She got her employers to sign off on this. It says the employment of the petitioner since his discharge has been as follows. She was working as a laundress and doing housework by the day. She had 3 employers' names and addresses on there. You can see on this next form that she also got a pile of people to sign it. Now, what I think is really powerful about her form is that now in 1932, she asks some women to sign her form. So the last one we looked at from 1921, that was all signed by men. But now about 10 years later, she's getting both women and men to sign her form. And that makes me think about the fact that when you have the right to vote and full rights of citizenship, it includes broader rights also, right? So in 1921, maybe people weren't real sure if women counted on a form like this. But now in the 1930s, many women are like, nope, I'm going to sign her form. I am going to attest to the fact that she should get to vote. You can see again here on the right side, these are people that are working as undertakers, housekeepers, chauffeurs, florists, housewives, and so on. You can see on the bottom right corner, though, she is able to get a few really significant people to sign her form. She gets the deputy sheriff. She gets a state representative, the editor of a newspaper, deputy marshal, justice of peace, and deputy sheriff. So you must think she was probably really proud when she got those. She probably figured that once she got these important people that held a lot of political and social power, she too would probably make it over the line and get her voting rights back also. Now, I wanted to point this out, particularly because I know some of you are students and you're probably looking for research opportunities. I did some quick searches and it's pretty easy to find these kinds of documents for the state of Rhode Island, at least in a shortened and summarized form like this. One of the assets or one of the advantages of the fact that Rhode Island has restoration of citizenship by act of the General Assembly is that petitions for restoration of citizenship are in the General Assembly reports. So you can pretty easily go to your state library and archives and take a look at the General Assembly reports and find pages and pages of these petitions by citizens in Rhode Island to get their voting rights back. And probably if you started looking at the ones from the 1920s and 30s, you could see some of the first women in Rhode Island with prior convictions making the same effort. And so I wanted to conclude to think for a second about why all this matters. Why does the history of women and felon disfranchisement matter to how we think about the women's suffrage movement and the history of women's suffrage activism? And as I'm sure you've talked about over the course of this long series, there are different ways to think about the legacy of women's suffrage. On the one hand, we want to think about 1920 and the 19th Amendment as a victory. And I don't ever want to minimize the significance of that victory. This is a long and successful struggle that women won. At the same time, though, when you look at the experience of women with prior criminal convictions, you realize that this was only a partial victory. And women like Anna Hunting still couldn't vote and had to go through difficult processes that were not guaranteed. And finally, in some cases, got the right to vote. But in many cases, people that didn't have the wherewithal to fill out forms like that and get signatures from their neighbors remained disfranchised after 1919, and in fact, still today. So it's a reminder that we have to remember that 1920 was a partial victory from which many women are left out. And finally, it's a reminder to me that it's a way for me to think about women's suffrage as a long and ongoing struggle. And the protecting and expanding voting rights in the United States has been a long struggle. It's been a struggle by women. It's been a struggle by African Americans, by Asian Americans, by Hispanic Americans, by immigrants, by all kinds of populations, by disabled people who have also faced major obstacles to their ability to vote. And this is a struggle that many populations have worked on, many of us have worked on, and it's not inevitable. And we've seen, particularly in the last few years, that what maybe for some might be a march of progress has also in many cases gone backwards, and the right to vote is getting more restricted, and being able to vote is getting harder for many people in America. So for me, thinking about women and felon disfranchisement is also an opportunity to think about the successes as well as the failures in our democracy. Thank you. I'd love to hear your questions and get the opportunity to talk more with all of you about this.
That was absolutely fantastic. So I just want to say thank you, Dr. Holloway, for everything. To those that are watching, please, if you have any questions or if you have any comments, please drop them in the chat. We're going to answer a few questions if you are up to it. Do you need another sip of water, or?
I reserve the right to take sips intermittently throughout, but I'm good for right now.
That works for me. I guess we are ready for the first question.
Hello, my name is Carly Kerr. I'm a senior at the University of Rhode Island. I'm double majoring in history and gender and women's studies with a minor in African American studies. And my question today is in regards to your thoughts on the various forms of oppression that we see so often play out throughout the American justice system. So for example, in relation to felony sentencing and the different ways that we see certain demographics are given longer sentences than others. And I was just wondering what your thoughts on that were, but also how that has impacted voting numbers and the accessibility to vote. Especially when we talk about the limitations and prevention of voting with individuals that have felony sentences.
Oh, that's a great question. Earlier in my talk, when I was talking about racial disparities as well as gender and economic, all the disparities that mean that felon disfranchisement affects some populations more than others. I could have been more clear, and I want to take this opportunity to be more clear, to say that the reasons for example, racial disparities in incarceration, the reason that African Americans and Latinx people face incarceration at higher rates are not because they're committing more crimes. It's because of all the things that great question pointed out. It's because of disparate sentencing, disparate prosecutions, over-policing certain communities, lack of access to appropriate legal counsel, lack of discrediting of witnesses from that community. So when people testify, some witnesses are believed more than others. Some evidence is counted as more weighty than others. So those are all the reasons that we have racial disparities within our criminal justice system. And for sure, these follow people out of the criminal justice system and affect their voting rights also. And that's why we have situations like in Florida, where 1 in 5 African Americans can't vote due to a prior criminal conviction. And so the questioner is really right to say we have to think of all of the reasons and how all of this connects together, and how that comes down onto one person's body. One person can't vote because all of these things have added up and affected their ability to access citizenship.
Awesome. Okay, we will take the next question. So this question is from Catherine. Do you believe that the states who deny ex-offenders their right to vote are violating our constitutional right to vote? And if so, why?
Oh, that's a great question. And I'll be honest, when I first started this book, many years ago now, my goal was to prove that the 14th Amendment was being interpreted wrong. Okay. So in other words, remember that line I underlined where I said that you can lose the right to vote for rebellion or any crime? I was hoping to prove that that meant just the Civil War. So let me be a little more clear. Courts have interpreted that line to mean that the 14th Amendment was intended to exclude felons. The people that wrote the 14th Amendment said felons should not get to vote. That's what the courts have said. And I was hoping that my historical research could prove the courts wrong, and that I could prove that that line wasn't intended to disfranchise all felons or to allow states to do that, that line was intended just to disfranchise the Confederate rebels. I mean, after all, it does say rebellion or other crime, right? I did a lot of research, and what I realized is, first of all, it's really hard to figure out what they exactly meant when they passed that provision in 1866. They might have all, it's Congress. There's 500 people in there. They might have all thought different things, 400. In addition, in the years afterwards, in the few years after, it was pretty clear that the 14th Amendment was offering something of a loophole, and that laws disfranchising for crime were being used to target broad swaths of the population. And Congress refused to act, and this was never stopped by Congress. For example, the 15th Amendment could have had something in there that limited felon disfranchisement. That was actually on the table. When the 15th Amendment was offered up or was being debated, there was a discussion as to whether restrictions should be put on the ability of states to disfranchise due to prior criminal convictions. And Congress said, "Nah, we're not going to touch that." So this is a long answer to your question, but here's my answer. I don't think that there is a basis for finding felon disfranchisement, broadly speaking, unconstitutional. I think there's more room under state constitutions to litigate this, and we can see that playing out in a number of states at present. There's pending litigation, for example, in North Carolina right now. And I think that there are ways that it's being applied that might violate due process and equal protection, specifically equal protection, that should be considered. But I think ultimately this is a policy issue. This is a place, in our democracy where the way it gets fixed is through Congress, through ballot initiatives like y'all did in Rhode Island, through legislatures. And while it would be nice to hope that courts could waive this away, the reality of this is that the way that this is going to change is the way it's been changing, and that's through legislation and democratic processes.
Awesome. That was a great answer. We're ready for the next question, please.
Hi. My name is Sam Van Geisen. I'm a senior history political science student here at URI. My question for Ms. Holloway is, why are prisoners such a targeted and feared group from government and law enforcement officials, even when they have historically been a powerless group?
Oh, that's a good question too. That's a really powerful question too. I think there's a lot of ways to think about this question, and a lot of ways to think about this question that involve issues of race, issues of gender and sexuality, issues of class and ethnicity. But I want to highlight one in particular that I think comes out of my research, and that I think is a fairly kind of important contribution of my work. And I alluded a little bit to it earlier, which is that people that were in prison, people that were incarcerated historically, and people that were enslaved were in very many ways considered similar populations, similar status, and similar levels of kind of contempt or degradation from the rest of the population. And even if you think about it, when we think about enslavement, people would often refer to as enslaved people as people that were in bondage, right? And that literally means like locked up like in prison. Incarcerated people could face violence. They could be whipped, they could be tortured, they could be abused in the same way that enslaved people were. They didn't have their rights. They could be forced to work. They were humiliated in public ways. And so I think that the more sort of complicated root of your question goes back to slavery and America's legacy of racial slavery. And so I guess kind of the way I'm thinking about this is to say this is one of the many, many complicated and horrible legacies of slavery in the United States. And it's easy to think about, not easy to think about, but we often think about maybe slavery as something that, you know, thank God it's over, we're past that. But the repercussions of it, the reverberations of it are incredibly complicated. And I think still do haunt us in ways that we have to keep looking for. And that's one of the things that I'm proud of about my research is I think I'm trying to argue that this is yet another legacy of slavery. And this is yet another way that has kind of poisoned our current politics.
I want to say thank you for saying enslaved people, by the way. I know people are still grasping that term, so thank you for saying that. We will take the next question. Let's see. This question is from Rebecca. This is regarding the 14th Amendment. Does the heavy use of male references suggest that advocacy for women's suffrage was already present and the amendment represented a response to that advocacy?
Oh, good question. Really complicated question. There's a lot going on in 1866 for a lot of people. There were women's suffrage activists. I might turn that question around a little bit and say women's suffrage activists were aware that the amendment was being debated, were pressuring Congress, and were fit to be tied that men wind up in the 14th Amendment, not one, not two, but 3 times. There are debates at this moment within Congress and within the larger American population over maybe I'll put it this way. What's going to change after the Civil War? And it's really, really clear to a lot of people that what needs to change is America's system of racism and slavery. And many people think at that time that that's really all that we should just have that in 1865, that we have just ended slavery. We have just shifted what citizenship means in America to include African Americans, and we should just focus on that. And other people saw 1865 and 1866 and 1867 as a moment in which we should rethink what citizenship means, that we should bring women into it, that we should bring African Americans into it. We should underscore that citizenship is a basic right of everyone in this country, and voting is part of that. And those two ideas clash, and one of them wins out, which is the idea that the 14th Amendment is going to be primarily about enfranchising and guaranteeing the rights of African Americans at the time. And that, in fact, women are not going to be included in it at all. And the kind of, beautifully ironic legacy of that is that in the aftermath of that, in the past, say, 100 years of justice and litigation in America, the 14th Amendment has been used to expand rights for women, most recently for LGBT people, and that the work of the 14th Amendment had really just begun in 1866. And the work of the 14th Amendment continues today. And it's still an opportunity for all of us to realize a vision that was begun in 1866.
Awesome. So we have a few more questions left. So we will take the next question, please.
Hi, my name is Danielle Swan. I'm a sophomore secondary education and history major. And my question is, do you think that comprehensive education and also more resources offered to those who are incarcerated for a felony would make a substantial change in the way that people with felonies are treated once they are released? And what I mean by that is the way that the general public views them. And if prisons offered more resources and education while people are in prison, do you think that would change the way people view them? And also a more comprehensive education for the general public on mass incarceration and felony disenfranchisement, do you think that would make enough of an impact? Or do you think that mass incarceration and felon disenfranchisement is too deeply rooted in racism and other historical aspects for that to make a substantial change?
You know what I love about that question is that she starts off by talking about educating incarcerated people, but then she tips and says, well, we actually all need education. And I thought that was a really astute and very smart observation. I mean, the answer, you're not going to get a college professor to ever suggest that more education isn't necessary. I think definitely we should all get more educated. People that are incarcerated, people that are not incarcerated, college professors, politicians, we could all use more education, and we all need to keep dedicating ourselves to that. But the more serious aspect of her question, I think that would be a step, right? There's all kinds of reasons why people who with felony convictions face a billion different obstacles. And some of those, yeah, they might have, for example, more job opportunities, more opportunities for economic advancement with more education. But I remind you to go back to that list of, what is it in Rhode Island, 242 things that follow you out of prison. And if you start going through that list, you'll realize you can't be a social worker. You can't be a detective is on that list. You can't be an accountant. You can't be a loan manager at a bank. You can't be a plumber. You can't be all these things. So you can't be a lawyer. So you could get someone a law degree in prison, and when they got out of prison, they still couldn't be a lawyer. And so education's part of it, but changing those collateral consequences would be another part.
Yeah, I know that's in the state of Rhode Island. We've been working on licensing, fair chance licensing for people who have been convicted. But hopefully everything will pass the way that it needs to pass. It has passed a few years ago, but it needs to expand.
And some of those are not legislative; they're professional. Like, you know, so you can't convince you can't just change the law about accounting. You also have to convince the accountants.
Yeah. Yes. Okay, we'll take another question, please. Oh, this is another one. So, is the United States unusual with regard to its felon disfranchisement policies?
Yes, and I'll answer that in an even broader way, which is to start by saying the United States is, first of all, unusual with regard to its system of mass incarceration. As I'm sure many of you know, the United States jails more people than almost any country in the world. I believe China, Saudi Arabia, and North Korea are maybe Iran are maybe our peers on this, but we are definitely in the top 5 or 6 in terms of people that are incarcerated or formerly incarcerated. With regard to voting rights, there's been some international or transnational studies of this. I would say with regard to Western democracies, we are very much an outlier. European countries, in most European countries, you can vote while you're incarcerated. You can vote after you're incarcerated, not an issue at all. There's some Latin and Central American countries that have similar provisions. Beyond that, I'm a little beyond my knowledge base. But my general sense is that, yes, we are very much an outlier, certainly with regard to Western European democracies.
That's awesome. And for the last question tonight, is Black Lives Matter increasing pressure to reform the laws?
To some extent. I mean, the kind of good news here is that many states have reformed their laws. I mean, I showed you the information that says that Rhode Island reformed its law in 2006. Since then, many other states have. There are ways that Black Lives Matter has brought attention to racial disparities. And also, and I think more importantly, a reminder that in all states, there's still work to be done, right? I certainly don't want y'all in Rhode Island to sit back and say there's nothing to do here. The next step for places like Rhode Island, for Maryland, I actually met with some activists recently in Maryland, is voting for people while they're incarcerated. So remember that our brothers and sisters behind bars are parts of our community. And to say we're not going to stop now. Y'all did an amazing thing in 2006 when you passed your ballot initiative. Let's follow in the footsteps now of places like Maine and Vermont, California, which is moving in that direction, Maryland, where this kind of legislation is being introduced. Keep pushing to say, what can we do to continue to expand the voting rights for all of our people inside incarceration and outside?
Awesome. Thank you so much. This was awesome. I enjoyed your book. I read it. I truly enjoyed it because being someone who's running for office, you want to learn as much as possible. But we are going to bring Dr. Miriam back in so that we can continue. So Dr. Miriam, thank you for coming back.
All right, thank you. A really big thanks from all of us to Pippa, both for her talk tonight and for the power of her research and analysis. I especially love that she threw out some research suggestions for our students. Great, Pippa, thanks. Thanks also to Jennifer and for everyone who was part of the suffrage series, and of course to members of the audience. We really appreciate you showing up, asking questions, and sharing on social media. A couple final things. If you are interested in watching recordings of any of the suffrage series from the past year that you might have missed, they're available at uri.edu/suffrage. We also suggest that you follow the Center for the Humanities in order to get information on next year's programming. Last of all, if you're on the URI campus, check out the Votes for Women exhibit currently up in the lobby of the Carruthers Library. Good evening, everyone, and thank you again.